Good afternoon. It is my particular pleasure today to welcome Deirdre Curtin back in Amsterdam to give a talk on the executive power in the EU. My name is Christina Ackers. This is the series of lectures of the SepaRope, Separation of Powers in the 21st Century Europe series. And this is a cooperation between the Amsterdam Center for European Law and Governance in Amsterdam, the University of Helsinki and the University of Gothenburg. And we are particularly happy to have Deirdre Curtin back because she's the founder of the Amsterdam Center for European Law and Governance now and since 2016 at the Robert Schuman Center at the European University Institute. And well, we're very happy to have you back. And without much further ado, I will let you speak to us about transparency, technocracy, and the executive power in the EU. And we hope to learn a lot for our own conceptualization.
Okay, thank you very much, Christina. I hope you can hear me. I'm a little uncertain about my Wi-Fi, but so far so good. I'm delighted to join you all, even really played in this lecture series. By the way, I'm at the law department of the EUI. Christina, I haven't been at the Robert Schuman Center for a long time, but that's a small difference. So the title of my lecture today is Seeing Power, EU Executive Technocracy in Crisis. So the title of my lecture is deliberately ambiguous. Is executive technocracy itself actually in crisis, or is my focus on it during one or more crises? In fact, it's the latter, although the former may also be a point for the discussion afterwards. Executive technocracy is a deliberately broad term. It covers a host of different expert involvement in the landscape of European governance. Although my focus is not risk regulation and management, I welcome engagement with those of you at ACELG that have long studied these processes of law. Advisory committees and regulatory agencies are generally perceived as indispensable to policymakers across a broad range of technical decisions. They inject much needed expertise and technical knowledge into a regulatory and executive system that otherwise would be subject to manifold political pressures. My focus is more specific. It's on the role of executive technocracy within the European Union during crisis or emergency-related decision-making periods. This is a very important strand of executive power that exists at every possible level of governance, national, European, and global. It's particularly visible, in my view, during the current health crisis. My research is not on separation of powers as such. Nonetheless, by highlighting the expansion within the executive power of the role of experts and the information asymmetries that this brings about with the other powers, it has a contribution also to this debate. It highlights the way in which transparency can play a particular role within the EU system of governance while the crisis is ongoing. This potentially enables, at the very least, parliaments to be more proactive in checking and balancing executive power. It's of course not unusual in times of a national or global emergency that executive power expands and even dominates. Executive power, as we know, can be broken into two broadly component parts, what we can term the political executive on the one hand, and the more expert or technocratic executive on the other. The political executive, the government in a sense, has in fact in many countries in Europe and elsewhere been empowered, often in legislation, to extensively regulate the daily lives of their citizens during the pandemic in particular. This is often by decree or second rules with reduced input by parliaments and often following from explicit emergency declaration or legislation. Here, there is obviously a direct link with your project on separation of powers. The executive power is in fact drifting to a greater or lesser extent away from the other powers, parliaments and courts. There is variety in terms of the responses in member states, however, and for example, with regard to parliaments, it varies from a more robust response, for example, arguably in the UK and in Germany, to what has been termed parliaments on life support in others. This aspect of executive domination, clear though it may be, isn't what I'm focusing on. So the second expert or technocratic part of the executive has been greatly intensified, in particular by medical scientists representing a supposedly neutral and reliable source of information and judgment compared to the political level. Within the executive powers of almost all states in Europe, power has been concentrated in the hands of a small group, overseeing and providing direction and expert advice across the health service and the wider public service on the national response to the pandemic. Members are generally civil servants, other service executives, as well as medical consultants and epidemiologists. The core resource that enables these scientific experts to perform this role is their biomedical expertise. They are part of what makes the executive power the most knowledgeable branch. Their specialized knowledge and expertise brings with it status, reputation, and the perception of objectivity and independence. This imbues them with authority and generally credibility in the public domain. At the same time, their very expertise enables the medical or scientific experts to participate in public debate asymmetrically with other participants. In large part, because of this knowledge asymmetry, this phenomenon has been referred to as the rise of autocratic technocracy. Medical scientists are the technocrats in what is claimed to be this autocratic technocracy. And the reason why they can be considered autocratic is that they exist in a type of executive bubble with considerable knowledge and information gathering advantages over accountability forms that could offer some checks, parliaments and courts. That said, they are perceived to have pure motives, especially when compared to political, business and commercial interests. When this is coupled with complex and highly technical decisions, which have to be made on the basis of incomplete, to put it mildly, and shifting information, their discretion is even greater. It can be hard for governments to ignore advice from persons they have visibly put forward as experts. So this can also be very limiting for public debate and true deliberation. So for many measures, regulatory impact assessments will not have been undertaken, cost-benefit analysis will not have been prepared, and public consultation on the whole will not have taken place. Truly deliberation will not have taken place in the public media, given this asymmetry in knowledge and information sources. In most cases, it seems that the medical experts function as advisor and not as actual decision maker. And some governments have made a point of ruling specific, far-reaching and public advice by the medical scientists. In other states, the expert transitions from advisor to decision maker and combines the reputation and trustworthiness of their profession with the imprimatur and power of the state. To some extent, we see this at the European level as well. In principle, expert technical advisors cannot, should not substitute for democratic judgment in determining the public good. Yet the two levels are very intertwined. And one can see an example in the ruling by the European Medicines Agency on the safety of the AstraZeneca vaccine and the lack of discretion following that in substance for politics. EU executive technocracy in the form of the European Medicines Agency visibly decided whether the AstraZeneca vaccine was safe for continued use. Citizens in many EU countries, especially those states that had stopped using it in the meantime, and those citizens whose appointments were cancelled, they saw power in action and the influence on politics in a salient and immediate fashion. So seeing power is the first part of my title. it is meant to imply that we can see what is happening within the black box of EU governance related to, in this instance, the pandemic. If this is the case, how is that so? In the AstraZeneca example, we saw the outcome of the process and the impact at the political level. Yet my lecture speaks to the fact that much of the details of the power may in fact be hidden. We may even speak of invisible politics. Now, admittedly, the European Medicines Agency was far from invisible, and politics in all affected countries were on tenterhooks to see what it would decide in relation to the AstraZeneca vaccine and immediately restart. The audiences were national, even for the supranational European Medicines Agency. But was more known than the outcome. If we, the public, or other accountability forums cannot see what is happening, who engages on the basis of what information, then there can be no question of any account giving in a manner that actually relates to the nature and content of the input to the political executive at any level. At the European level of governance, can we actually normally see the expert power that is exercised? Can we peer into the black box and view at least some of what is happening in insulated or sheltered spaces? What used to be called access to information or documents in the European Union is now often included under the more generic term of transparency. The very word transparency implies visibility, ability to see through. It implies a subject seeing as well as the object being seen. Transparency is increasingly understood not as a coherent normative ideal, but as a means for a more granular description of processes of government and governance. The relational side to transparency leads quite naturally to a more empirical focus that studies transparency in its complexity as a social phenomenon and the possible effects on the circulation of power within institutions. It is also about joining up the dots as to who is involved in decision-taking, how, and on the basis of what information. It also speaks to another debate about the legitimacy of EU executive technocracy within the executive power more generally. Does transparency as a tool work as a way of providing more throughput legitimacy to these processes, as opposed to either input or output legitimacy? The latter is a debate that has been largely conducted among a group of political scientists, but it may have some resonance within law as well and within a broader context. My starting hypothesis is, however, that one cannot equate more transparency with throughput legitimacy as such. And we can debate this later if you like. Today, I will only elaborate on the current crisis that we are all living through and the role of medical scientists, epidemiologists, and other experts in this context. So using transparency as a tool to track whether information is available online or otherwise is the thrust of my lecture that looks at two key agencies as well as the role of the Commission's experts. These are the largest, at least in European Union terms, European Medicines Agency, and the much smaller European Centre for Disease Control, the ECDC, and as well as the e-health network, which is nestled within the European Commission, but composed of representatives of member states and their experts. These three examples illustrate, in my view, different types of governance, both supranational governance and more composed or composite governments, either with input from the member states or also from private actors. So this is just a preliminary examination, I should say, at the early stages of what is the beginnings of a new research project. I'm not claiming that this is the selection of case studies that needs to be made, but it is the one that is accessible at the moment. For the ECDC and the EMA, the European Ombudsman has played a significant role in opening up internal processes to the outside. At the same time, it has prompted active institutional responses by the agencies themselves, in particular the European Medicines Agency. For the third case, concerning the e-health network, it is almost completely opaque, despite being located formally within the Commission itself. Now, I'll go through each of these three cases with you a moment, and do that as briefly as I can. So starting in a sense with the best case, to put it in those terms, the European Medicines Agency. It has been the subject of long-standing transparency concerns by the European Ombudsman in particular, and it has been quite extensively litigated as well over the years before the European courts. This had to do with introducing Chinese walls between those experts involved in giving scientific advice to the medicine developer, pre-authorization, and those actually involved in the authorization process. So the European Medicines Agency has been very conscious of the visibility and political salience of its decisions in the EU context. And it has developed, in fact, during the pandemic, what it itself describes as exceptional measures which maximize transparency and go far beyond the information it normally places online for other medicines. And indeed, the Ombudsman has accepted that, despite opening an own initiative inquiry during the summer of 2020. The Ombudsman has now accepted that the progress made by the EMA is sufficient and has closed the inquiry on the basis of its own proactive measures. Despite the fact that there may be reasons for some confidentiality in normal times, when looking at the concrete new measures adopted by the EMA, they don't seem to be of an exceptional nature, but rather can be made general also in normal times. And this applies even more so because some of these measures relate specifically to normal intake procedures, such as information on whether a producer has scientific advice or guidance. In this case, from the special COVID task force, but advice is provided by others also in normal times. And it remains to be seen what the response will be of the pharma companies to this sort of maximization of transparency. In the past, they have challenged, they have actually been the stakeholders that have challenged the agency's attempts to have more transparency before the courts, which has given rise to some interesting case law, with the courts essentially rejecting a general presumption of confidentiality and also emphasizing, and I quote from the court, the transparency of the process followed by the EMA and the possibility of access to the documents used by the agency's experts to prepare their scientific assessment contribute to such an authority acquiring greater legitimacy in the eyes of the person to whom that measure is addressed, and to increasing their confidence in that authority, and to ensuring the authority is more accountable to citizens in a democracy. So this is arguably an essential finding, as it underlines authoritatively that the interlocutors of the EMA for whom they are being transparent is also the citizens of the member state, and not just the stakeholders, the commercial interests of the private companies involved. Moving then to the middle case, where some progress has been made, but there's still a long way to go. And this is the Ecdc, which is a different kind of agency, a very small one with limited resources, and until the pandemic was virtually unseen in terms of European governance. And it's interesting that now it's one of the centerpieces actually in the Commission's proposal for a European health union in terms of being revamped and given a new, but that's not what I'm going to discuss with you today. So its role, the role of the ECDC, is to identify, assess, and communicate current and emerging threats to human health. And it provides the EU with independent scientific and epidemiological advice on emerging threats to human health from infectious disease. Its primary interlocutor is national public health administration, and it operates in partnership with them. The kind of authority it exercises is more composite in nature, as it depends very much on information from the member states themselves through a variety of different information systems. Now, here too, the European Ombudsman carried out an own initiative investigation, its first, on certain aspects of how the ECDC gathers and communicates data from both international and national sources. The issue of confidential information was raised in this context too, with member states requesting confidential treatment of information shared with the ECDC in the context of the crisis. Now, there is much more of a box in existence in relation to the ECDC than the EMA. Very little information is available as to how it treats confidentiality requests, nor is it publicly known what information security systems it has in place, what they are modeled on, nor how they operate in practice. The European Ombudsman was able to play a pivotal role in inspecting documents, interviewing staff members, publishing online detailed letters and responses of the ECDC, as well as its meeting reports, all of which lift the cover, a bit at any rate, on the black box. Now, it issued detailed recommendations, and of course, I'm not going to go into that. It's also not my purpose today, but it remains to be seen what it will do with these detailed recommendations. In particular, the issue of the member states' ability to insist on the confidentiality of their own sources will likely remain a hot potato. Now, I'm not suggesting that this is unproblematic, because given the nature of the kind of information and perhaps the notification of serious emerging health threats, there will be a need at times for confidentiality. So that needs to be looked at very carefully. But what I'm attempting to do is to go a little bit into certain examples to see what it is that is happening at the EU level, and then I will at the end zoom out again to the relevance for the broader issue of EU executive power and perhaps executive power more generally. But my last example, the final case, relates to the eHealth network. Now, even though I had in another life, a supervisee who wrote at the time, quite a long time ago, about all these issues, one didn't expect that this would have come in to a more sort of central and pivotal attention that it now has. The eHealth network, there is no clear history of transparency being applied. There are no pre-existing court cases. There's no own initiative inquiry by the European Ombudsman. And until now, it could be thought that it was actually of fairly marginal significance. It was set up under a directive on patient rights and cross-border healthcare, connects national authorities responsible for eHealth under the auspices of the Commission. And through this kind of voluntary network, EU countries can give direction to e-health developments in Europe and help shape policy on interoperability and standardization. Now, this all sounds very technical. It meets normally approximately 2 times a year, and it now has met, well, in the first month crisis last year, I think up to July 2020, it had met 30 times. And since the start of the COVID-19 crisis, it worked intensively to achieve interoperability of tracking, contact tracing apps across states and to ensure their contribution to public health efforts by national health authorities. Just very briefly, because again, I don't want to get lost in the technical detail. So at first, most of the countries opted for a centralized model to give more access and control to health authorities to crucial data to evaluate the pandemic's evolution. And against this tendency, a first turning point was the increasing commitment of EU institutions in making these apps interoperable. In other words, that they would talk to another from the various member states. Although not explicitly imposed on member states, many EU documents indicate quite early on a preference for a decentralized model. The real U-turn was primarily determined by Google and Apple when they announced their partnership in creating the API based on what is termed the exposure notification system. And they chose the decentralized model based on Bluetooth technology. In the meantime, the European Commission was cooperating with national health authorities within the eHealth network to create what is known as a European Federation Gateway Service. This is the European solution for the interoperability between national back-end servers of decentralized contact tracing applications. Once connected, national apps would communicate with each other and work across borders. By the end of September 2020, the process was completed. After this, member states, the vast majority of member states, not all of them, gradually connected to the system. Now, the use of these systems might look merely technical, but they have a broad political and even arguably democratic component. First, technical choices such as Bluetooth technology and the adoption of a decentralized system for data storing shape how data is processed, hence will have a different impact on individuals' privacy. Second, relying on big tech companies for developing the apps challenges the foundations of public digital sovereignty and impact the distribution of power between the public and private sphere. The influence in the decentralized model's choice raises questions about power distribution. In a decentralized approach, the operating system generates the pseudonyms, whereas the centralized one is driven by the central authority, potentially identifying the people if necessary, you know, at the national level. By choosing the decentralized system, Google and Apple de facto took control over managing the data collected by the apps, imposing on the national health authorities the acceptance of their terms and conditions. And also the European Data Protection Supervisor has expressed concern at this, and that citizens, business, member states, they're gradually losing control over their data and over their ability to shape and enforce legislation in the digital environment. So what was the discussion, if any, with the private companies? Who made the decisions? Can we trace the process in any meaningful way? All the output data are publicly available and easily accessible. In particular, the technical documents produced by the eHealth network can be downloaded from the official website. What is missing are the minutes of the meetings and the list of members. I've already said to you that there have been, well over 30 meetings. But there is documentation available for only 2 meetings in 2020, and there's no information on the subgroups. And the report by the European Commission refers to the dialogue established with Google and is quite explicit on it, in fact, but there are no trace of those meetings. And this information is arguably crucial to have insights into the discussion that led to the adoption of those guidelines and further avenues for public accountability. The hypothesis that still needs to be tested is that since the discussion on interoperability has been considered purely technical, in inverted commas, devoid of a democratic value, the documents produced in the decision-making process are not available. The consequences of interoperability are relevant to the public as it can impact individuals' rights. Hence, labeling the discussion as merely technical should not justify the opacity of the decision-making process, especially when interlocutors are involved, private companies, large, powerful private companies such as Google and Apple. Okay, let me in conclusion zoom back out, as it were, to where we started. The expansion of executive power. even with my choice of title, I place expert technocracy within the executive power. So there are a number of possible implications I would like to mention, inclusion, all requiring further debate and research. My first point relates to the information asymmetries of parliaments in particular. Experts within the executive branch have a considerable knowledge and information gathering advantage over the legislative and indeed judicial branches of government. Parliaments become now quite literally remote, without transparency of the data, of the models, of the information, of the process, of the actors, and of the decision-making. Further institutional accountability becomes very difficult, if not impossible, for any accountability forum. This is a key point. An important step, so I think we need to reflect on what can parliaments actually do to start to counteract that. And I think they need their own instruments that they have, such as a hearing, invite their own experts, and look to give flesh to a new role that is not only perfectly aligned with their control function, but is actually an expression and a necessary tool to fully achieve that function. So in that way, they could engage, as it were, in an ongoing manner on the fast measures that need to be undertaken. Sorry, I've got an animal. So this would continue to be only an ex post application, but it could change its character from being a mere formality to being one of substantive control of the executive that does not rely on the same and inevitably provisional data that the government had used or the political executive. And it would alleviate the reliance of parliaments on executives' willingness to make their own expert information available. So my second point relates to transparency. As we well know, and many people here also know it, transparency can be both passive or active when the institution reveals of its own account information. The European Union fares reasonably well, it seems, on the basis of the 3 case studies. But there are institutional factors, 3 in particular, that explain why that is the case. In the first place, there are established agencies, an active ombudsman who starts own initiative inquiries, and there is thirdly an expert register by the European Commission. I haven't discussed the latter in my lecture, but a fruitful line of further inquiries to explore how the eHealth network experts and private parties are included at all in this register, and whether documents are included in the Commission register of documents. Are there lessons to be drawn from how agencies become incrementally more transparent and how this could apply to a non-agency executive structures? This could also be part of a wider debate filtering down to the member states. A role model function could stem from the fact that in agency cases, the role of experts is still central, but at least the relationship between the experts and the executive or political actor, for example, the Commission, is clear. There's no uncertainty about the core actors, whereas the impact of experts remains unclear in the case of executives deciding on the basis of advisory committees that work in an opaque manner. For example, in Spain, the government for months even refused to publish the names of those on its COVID-19 pandemic expert advisory panel. And not surprisingly, the figures on the lack of trust by the public in how the crises are being handled are striking. In some countries, more than 50% of the population consider the available information and the background to decisions to be inadequately explained. My third and final point relates to crisis. So I should start by saying, maybe I should have started my lecture by saying, that I am presenting an early stage research project to you that will explore different types of executive technocracies across different crises. Does it matter that the different crises I will ultimately explore at the EU level all concern core state powers, where the power of the European Union is fragmented? Arguably, this can be considered a real difference with the internal market and risk regulation. And does this engender differences in practice and how one studies it? At the end of the day, my claim, and the one I seek to or will seek to explore across several domains, is that executive authority is increasingly fragmented and out of control. That is my hypothesis, at any rate, starting off this fairly wide-ranging research project. Transparency as a tool may reveal gaps and whether one frames that in terms of legitimacy or accountability or public authority remains to be seen. In conclusion, many interesting questions for further study and reflection by scholars at all levels of governance in these times, national, European, and global. And I look forward to debating some of these further with you now. Thank you very much.